Court does call the case of the people of the state of Michigan versus Larry Lee.
Good afternoon, Your Honor. Retail Health System Prosecution Attorney on behalf of the people.
State your name, please, sir. Mr. Lee, you are here for your preliminary examination.
The atmosphere is heavy. The defendant, a man in his late 20s, sits at the defense table with his attorney. The prosecutor is at the opposite table, shuffling papers. The victim, visibly nervous, is on the witness stand. In the gallery, the defendants. Friend leans forward, watching intently.
Sir, you have elected to represent yourself. Is that still your wish, sir?
Your Honor, I have not received any of the requested discovery material. I've sent out written requests for the prosecution and my previous attorney and haven't received anything. So at this point, I'll be needing an attorney to assist, to represent me.
Your Honor, if Mr. Lee can maybe put on the record where he sent that request. I have not been informed with the discovery request from him. My understanding was that Mr. Burgess had a discovery return.
Well, there are two issues really involved. You sent out that you wanted a copy of your discovery.
That's correct.
Are you indicating that Mr. Burgess did not provide or share with you your discovery?
Correct. I sent out one to the prosecutor and one to Mr. Burgess.
Now, I'm asking a different question. At the point in time that Mr. Burgess is representing you, are you saying that he did not share the discovery information with you?
The only thing that I received was a police.
I was walking home from work when I heard footsteps behind me. I turned around and saw the defendant objecting, Your Honor. The witness is assuming overruled. The witness may continue. He yelled something at me. I couldn't understand what. Then he grabbed my arm suddenly, the defendant's friend, mutters something under his breath, just loud enough for the victim to hear.
For a 2-page report, that's it. So I didn't receive the file that he was referring to last court hearing. I didn't receive that now.
All right, let's just cut through the games and charade here. Do you wish to be represented by an attorney?
At this point, yes, I don't have any material.
Well, it's not an issue of the material. Do you wish to have an attorney represent you?
Yes.
Okay, under the court rule, he is entitled and can ask for that at any point in time. This is probably going to cause great inconvenience to people, and now here's the weird part of the system. While Mr. Drukas, I appointed as standby counsel, I need you to get to the back office and see what we can get. All right. Take it back. We'll get that resolved. Figure out what the back office wants to do.
When we come back, I just want to make sure I don't forget. There are a few things that you want to address that happened after the last court hearing. But we can do that when we come back.
Something that happened after the last?
Yes, Your Honor.
You were just full of surprise. It's fine. I'll deal with it then. Court's going to stand in recess.
All right.
Our lying. You know you started it. What did you just say? Oh, you heard me. I don't have to sit here and be threatened. That's enough. Both of you, stop talking. The entire courtroom freezes. The friend slowly stands, looking irritated. You are not a party to this case. You will not speak to any witness, directly or indirectly, during these proceedings. One more word, and you'll be escorted out and held in contempt. Do you understand me?
May be seated. Court does recall the case of the people versus Larry Lee.
On Retail Health System Proceedings Attorney on behalf of the people.
Good afternoon, Edward Drukas on behalf of Larry Lee.
All right. Mr. Lee, I've signed the order appointing Mr. Drukas to represent you in this matter so that you're aware. Okay. All right. So in this matter.
Set for a preliminary examination, I'm asking for a brief adjournment. I understand through timing with the court that Monday morning would be available. If we could set it for that time.
All right.
Opportunity to go over discovery.
Will that work for the people?
Yes, Your Honor. We'll have witnesses present.
All right. So preliminary examination in this matter will be adjourned. Court finding good cause to do so. I will adjourn it to what is it, the 11th?
Yes.
August 11th. 2025, 9 a.m.
Thank you, Your Honor.
Court meeting.
When the court's ready, I have a couple of matters to put on the record.
Yes.
Your Honor, first and foremost, after the last hearing we were here for, the victim was present with a support person. As they were leaving the courthouse, they were addressed by someone who identified themselves as the friend of Larry Lee. I believe that person is now sitting in the gallery here today. I personally warned her, but I would appreciate it if you could repeat that on the record, that the victim is not to be talked to or contacted. I don't have anything indicating that Mr. Lee directed that contact, but I want to make sure everybody's clear so we don't have any further issues regarding contact with the victim of this case.
All right. And which individual are you referring to?
Sit down. And if you so much as roll your eyes in my courtroom, you'll be explaining it from a holding cell. You may continue your testimony. I will ensure this courtroom remains safe for you to speak. The victim takes a deep breath and continues. As I said, he grabbed my arm. I tried to pull away, but then his friend came up behind me. Your Honor, the friend's involvement shows the full context.
This lady right here.
Ma'am, if you come out this way. Hello, what's your name? Yeah.
Hello, Your Honor.
What's your name?
I'm Jeanette Thompson.
What did you want to tell me?
Okay, so just to begin here, I'm very respectful. I don't know nothing that happened. When the I believe it's the victim was walking out, he was staring at me and I'm with three different women. And since he was staring at me, I said, are you so and so? I could identify him. So I think he was just irate because of what he going through. I don't know. But to be honest, I don't know that man. When he was talking, he was using verbal language. He walked back towards me and three other women and was kind of upset. And I said, I just want to know if you're okay. My bad. I could identify him. That was all it was. I said, I just want to know you okay. I don't.
Okay, so just stop you right now.
Yes.
So I don't want you to have any contact with the alleged victim in this case whatsoever. It doesn't matter if you are worried about whether or not they're doing okay or anything along those lines. You just not to have any contact, because ultimately, while the people don't have proof that Mr. Lee's involved with that, it could be attributed to him in regard to the behavior, and I don't think you want that to occur. All right. So I don't want any contact whatsoever. I understood.
Yes, sir.
All right. And if I do find out there is, at minimum, I would have you report.
Well, please, can you tell him not to walk up on me
I'm
again?
not gonna tell him that.
Okay, because that was
You
just
are, well, hold on. Here's part of the court proceeding.
right.
You are not.
Correct.
So you need to, if it's necessary, you need to get out of his way. There's court security if that
Got it.
becomes an issue for you.
Okay.
Or you can just make the election that you do not need to appear. If you want to see the proceeding that is happening with Mr. Lee, then certainly you may view that on YouTube. So there isn't a reason for you to be here.
Mhm.
There is a reason for him to be here.
Got it. Okay.
Understood?
Yes, sir.
All right, thank you. You can have a seat.
Thank you, Your Honor. One other thing regarding the discovery request that Mr. Lee said he had sent one to our office. I just received the email and
He'll allow it. But keep it to the events of that night. The victim nods and continues, detailing the frightening moments that followed. The defendant shifts uncomfortably. The friend in the gallery glares, but stays quiet under the judge's watchful eye. The courtroom tension is thick. One more slip from the friend could change the entire direction of the trial.
was labeled a FOIA request. So we went to our appeals and FOIA department. It appears it's a mix of, and I'll make sure to share this with Mr. Drukas, but essentially it appears he is attempting to FOIA communication that I may have had with the court, that I may have had with Mr. Burgess. There's also a grievance / investigation request looking to, it appears, grieve me, potentially more people. I haven't read through the whole thing. Somewhere in there's mention that he wants anything related to this case, but the overall idea and heading is FOIAing all communications that have happened in this case, as well as attempting to grieve myself and potentially other people. So I know at this point, Mr. Drukas is appointed. He'll get all the discovery. We've been in communication. I've asked our office to expedite the video discovery to him. I handed him a report that's unredacted, but it is the full police report. So we'll take care of that. But perhaps there should be a conversation Mr. Dukes wants to have with Mr. Lee about the rest of it and anything that may or may not be brought up as part of this case, and that the grievance process is a separate process, which he is entitled to.
Right. If that's what he wishes to do. All right. Anything from over?
Nothing further.
All right. Very good. Thank you, folks.
Thank you, Ron.
Everybody have a great weekend.
Thank you.
Bond will continue at this time. See you.